Whistleblowing can mean a number of things in any situation, but most commonly is a term used when employees report concerns either about their employers to an external authority or to their employers directly. As concept of ethics and criminal corporate liability have developed in recent years and received greater media and public attention, whistleblowing has become much more prevalent. This is particularly the case in the financial services sector, where the FCA receives over 1,000 whistleblower disclosures every year. What is the current landscape for whistleblowers in the UK? Well, generally speaking, there's no obligation on an employee to report concerns or to blow the whistle, but those who do might benefit from protection under the Public Interest Disclosure Act 1998. If the disclosure falls within that statutory regime, it offers protections for workers who report concerns against victimisation or dismissal. Now, some argue that the existing laws don't go far enough in protecting whistleblowers, and there are a number of private members' bills going through the parliamentary process currently. If any one of those bills is adopted, it may widen and significantly change the current landscape for whistleblowers. In order to encourage employees to speak up and explain their rights under the legislation, many companies implement whistleblower policies. A culture in which employees are actively encouraged to raise their concerns may be beneficial to management in helping to identify and remedy problems before they get out of hand.
For a whistleblower to have protection under employment legislation, they must make a qualifying disclosure. This must be a disclosure of information, not just an allegation, to someone within the organisation that relates to one of 6 types of failures or unlawfulness. The information doesn't actually have to be correct, so long as the whistleblower has a reasonable belief that it's correct and that it's being made in the public interest. These tests can often be easily satisfied, but it's always worth thinking about them carefully during an investigation when it comes to assessing whether someone does have whistleblower protection. It is possible for a disclosure to be made outside the organisation, for example to regulators, and still be protected, but additional restrictions apply. Any disclosures made more widely than that, including to the media, have much stricter conditions. For example, they must have first been disclosed through a proper internal channel and cannot be made for personal gain.
The main protections available to whistleblowers are protection from detriment during employment and from dismissal. Detriments during employment are widely defined and include most unfavourable treatment that may arise during employment, for example, opportunities for promotion, pay and even references. Often employees will claim lots of detriments, thus widening the scope of any litigation substantially. The main key to a successful claim by a whistleblower will be proving that the detriment or the dismissal was causally linked to the protected disclosure. And confusingly, the tests for detriment and dismissal causation are slightly different. Finally, in terms of remedy, the primary remedy is financial compensation to the whistleblower, which for a detriment claim can include an injury to feelings award. Where the whistleblower is highly paid, dismissed and unable to get another job, the compensation can be substantial. However, for lots of employers, the other major risk of a claim of this kind is the reputational risk, attaching to having the original protected disclosures and their reaction to them explored in the public domain. There may also be regulatory risks for an employer, depending on which sector they're in.
The whistleblowing rules in the FCA handbook apply to deposit takers and Solvency II insurers. For all other regulated firms, they're non-binding guidance that firms may adopt as best practice. It's important to be aware that what constitutes a whistleblower disclosure for regulatory purposes is much wider than the definition under PIDA. For example, it includes behaviour that harms or is likely to harm the reputation or financial well-being of the firm, and the disclosure can be made by any person, not just a worker. In investigating whistleblower disclosures, the regulator will expect firms to look at a broader set of factors that might apply when viewing issues purely through an employment law lens. So not just the what, but also the why. What were the contributing factors? Do any individual failings, systems and controls issues, or culture and governance issues indicate a need for a wider review? Where the firm or individuals act to the detriment of a whistleblower, this will call into question the fitness and propriety of the firm under the threshold conditions and as a senior manager or certification employee. So it's critical measures are put in place to protect against this. It's also important to ensure no steps are taken to identify anonymous whistleblowers. You must give a clear explanation that raising a whistleblowing concern to the FCA or PRA is not conditional on a report first being made to the firm, and that reports can be made simultaneously or consecutively. The PRA and FCA have taken action where they see firms not meeting these standards. And the restrictions on the wording of settlement agreements are also broader. Employment legislation provides that contractual provisions purporting to prevent workers from making protected disclosures are void, but the FCA requirements go one step further and provide that the firm cannot ask the worker to give a warranty requiring them to disclose that they have made a protected disclosure or know of any information that could form the basis of such a disclosure. And firms are also required not to use measures intended to prevent workers from making protected disclosures. So firms should therefore think carefully about including any provisions in settlement agreements that could be perceived as seeking to restrict or inhibit an individual's ability to make a protected disclosure in the future.
The biggest concrete upcoming change will be implementation of the Whistleblowers Directive across the EU, which must be done by December this year. It remains to be seen whether UK legislation will actually be updated to incorporate some of the newer obligations under the directive, but in any case, the UK already has one of the more comprehensive whistleblower protection regimes. That being said, UK organisations that operate across multiple jurisdictions would be well advised to keep a close eye on individual member state legislation, make sure their global policies capture the new obligations. For example, looking at the wider category of individuals who can obtain protection under the directive, as well as the prescribed processes and timings for responding to disclosures, which are all going to be highly relevant to the conduct of internal investigations.